Honorable Professor Tony Blackshield, Professor George Williams, family and friends of Macquarie Law School, alumni, students, ladies and gentlemen, good evening. Welcome to this annual Tony Blackshield lecture. I would like to acknowledge, before I start, the traditional owners, the direct people, and pay my respect to elders past and present. As you all know, when Macquarie Law School was established in 1972, it became the third oldest law school in New South Wales. Since then, Macquarie Law School has made its mark in legal education, undertaking innovative research, fostering interdisciplinary approaches to the law, promoting social justice and community engagement, and enhancing understanding of fundamental legal rules and institutions. An event like this provides us an opportunity to reflect on our past, on our achievements in teaching, research, and community engagement. We remind us that we have had proud moments of having Professor Tony Blackshield as an academic leader and scholar at Macquarie Law School, who has profoundly influenced our tradition and identity. The annual Tony Blackshield Lecture is an opportunity to honor Professor Tony Blackshield, given his formidable contributions to the Macquarie Law School community, including during his tenure as Dean of Law and to Constitutional Law Scholarship. The purpose of this lecture is to provide a platform through which Macquarie staff, students, alumni, and the Macquarie community can engage with public law issues of fundamental importance, such as Tony Blackshield has always encouraged in his teaching, in his writing, songs, and scholarship. We are delighted that Professor George Williams will present this year's annual lecture on the topic, The Legal Legacy of the War on Terror. Professor George Williams is the Anthony Mason Professor of Law and Foundation Director of the Gilbert and Tobin Center for Public Law at the Faculty of Law, University of New South Wales. Professor Williams was educated at Macquarie University, where he graduated with a Bachelor of Economics and Bachelor of Law with honors. And most importantly, Professor Williams was taught by constitutional law expert Tony Blackshield. He also holds a Master of Laws from Australian National University, University of New South Wales, and Doctor of Philosophy from the Australian National University. Professor Williams appeared in the High Court of Australia as counsel in some of the landmark cases and in the Supreme Court and Court of Appeal of Fiji. In 2008, Professor Williams was a delegate in the governance stream at the Australia 2020 Summit. In 2005, he chaired the Victorian Human Rights Consultation Committee that led to the enactment of the Victorian Charter of Human Rights and Responsibility. He also writes regularly for the Sydney Morning Herald and other newspapers. His books include Australian Constitutional Law and Theory, Commentary and Materials with Tony Blackshield, Labour Law and the Constitution, Human Rights under the Australian Constitution. In 2011, Professor Williams was named an Officer of the Order of Australia for his distinguished service to the law in the fields of anti-terrorism, human rights, and constitutional law as an academic, author, advisor, and public commentator. Ladies and gentlemen, it's my great pleasure to invite Professor George Williams to deliver his lecture on the legal legacy of the War on Terror.
Well, I'd also like to start by acknowledging the traditional owners of the land and to say what a great honour it is to be asked to give this lecture tonight. It's certainly a great honour and a privilege to do so at Macquarie University. I spent 5 very happy years here as an undergraduate student, and of course a particular privilege to be asked to give a lecture named after Tony Blackshield. I also recognise that I'm following in very large footsteps tonight, in that Michael Kirby gave a very eloquent inaugural lecture last year, which kicked off this series, and so it's a great pleasure to be asked to follow him tonight. Going through the acknowledgements, I think also I'd like to acknowledge some of my teachers who are here besides Tony, and I'll talk to Tony in a moment, but there are some people in the audience who taught me in the late 1980s and early 1990s here at Macquarie Law School. Ian Stewart, Malcolm Voice, Shane Davenport. I hope I haven't missed anyone, but there are people that I certainly remember very fondly for giving me an exceptional legal education at that point, a very fine law degree, and as I said, it was a very happy period in my life that I spent here. So I'd like to acknowledge what I gained from my legal education here and what a pleasure it is to come back to Macquarie Law School. Now, I was a student of Tony's back in 1989, and I was then, well, some 24 years ago, I was then in my 3rd year of my Macquarie Economics law degree. Tony taught me what was then called Australian Government 1 and 2. The names, of course, have gone through various incarnations since that time, but essentially he taught me both of the compulsory constitutional law subjects. And it's fair to say that Tony's teaching is very much etched in my memory. You can't forget Tony's style of teaching very easily. Put simply, he was a brilliant teacher who combined an encyclopedic knowledge of the law, and I mean encyclopedic, both in terms of the size of the materials that he gave us, but also in terms of the density of the material that he gave us, with a very rich repertoire of stories, anecdotes and the like. And as students, we would frequently do whatever we could to get Tony away from the legal material into his stories, because they were without doubt the highlight of his teaching, and I'll return to some of those in a moment. Now, Tony, apart from being a brilliant teacher, was also a very hard taskmaster, and I do remember that. I've always adverted to the fact that it was encyclopedic, and it was in the sense that every class we tended to get a very large volume of materials, and these would run over many tens of pages, and I did wonder at the time whether some form of war rationing perhaps was in effect, because the pages themselves had text going almost to the margins on every single page, and the font, well, if you bought a magnifying glass, it was a very sound investment for that course. So we had tens of pages, small type, right across the page, and Tony was obviously determined to fit as much as he possibly could in to every page. I suspected perhaps that he thought you shouldn't give perhaps students more than 40 pages of reading per 2-hour class, something along those lines. So his challenge was to get as many words as possible into those 40 pages to keep within what he thought was a reasonable limit. It turned out, of course, that those 40 pages amounted to about 160 pages for any other course, and there were few students indeed who I suspected got through everything that they were taught in the reading. And I must say that that was another reason people like to try and get Tony onto his anecdotes, if only not to be exposed for not having got to page 38 of these 40 dense pages every class. Now, Tony was also renowned in his teaching for his feedback, and in fact I've still got some of my assignments, and I kept them soon afterwards because they're quite striking, and I've never seen anything like it before or since. Now, Tony was not shy in using the red pen. In fact, I would say that Tony really loved using the red pen, and as I flicked through the pages recently at my feeble efforts at constitutional law back from 1989, I was met by swathes of Tony's own red pen, going through my limited and feeble analysis with what we'd have to say were masterly comments that were completely beyond me, I would have to say at the time. And I did wonder at the time, as Michael Kirby mentioned last year, why we as students had a word limit when the marker did not. Because it was quite clear that Tony had exceeded what I had written, at least in some of my assignments. And I can only imagine the amount of time that he spent actually doing the marking. When I was going back through those assignments recently, one of his comments actually returned to me, and I remember being very pleased at the time that in one of my essays I had what I thought was a thoughtful paragraph on the engineer's case, and Tony wrote in the margin, "Very thoughtful and balanced, Cooper-esque." And Michael Cooper, of course, is a very eminent constitutional lawyer, but on reading the paragraph I realised just how generous Tony was to me and how unfair he was to Michael. given the quality of that paragraph, but Tony was a hard but generous marker. Now, as I've said, a lot of Tony's teaching was renowned for the anecdotes and the like, and even though I must admit that some of the text and the legal material now escapes me, I do have very fond and clear recollections of the stories that Tony would tell us. I remember Tony telling us about Justice Lionel Murphy on the court and how Lionel Murphy would keep a copy of the Constitution by his bedside. It was the only cure for insomnia he had ever discovered. Or how Justice Eddie McTiernan broke his hip while chasing a cricket in a hotel room and had to resign when Sir Garfield Barwick refused to build a ramp into the High Court building. These were the sorts of stories that really brought the subject to life, and it's what I think made Tony an exceptional teacher beyond his obvious mastery of the material. I think more than anything else what I learned from Tony in these courses was not just the basic principles, but I really learnt, I think, for the first time with great clarity, just how much our rules and the Constitution in particular is dependent on the vagaries of circumstance and the vagaries of personality, how the law is a living instrument shaped by the people who make it and interpret the Constitution. And I think more broadly, I really came for the first time to understand, and it was awakened in me, the actual and potential connections between this body of law and social justice. I came to see that this was a body of law that was subject to change, dependent on the people involved, and that perhaps there was a career that might be involved in this area for someone interested in this area of the law and the possibilities. I'd also have to say that I was very fortunate that my connection with Tony and my relationship didn't end in 1989 with that subject. Tony supervised my legal honours thesis. 2 years later, I wrote it on the Communist Party case, and consistent with Tony's own relaxed approach to word limits, I handed in a monstrous 40,000-word undergraduate thesis on that case. And inspired by Tony's teaching, I was very much attempting to unpick that decision, to understand the extent to which it was a product not just of the legal rules but of the people involved, and of how that decision had shaped and was shaping the politics of the time. After I graduated from Macquarie Law School, Tony was kind enough to write a reference to me that enabled me to get an associateship at the High Court with Justice Michael McHugh. It was a very generous reference, and I arrived there in 1992, and I worked there at the high point of the activism of the Mason era. I got to work on cases such as the Mabo case, the free speech cases, and indeed it was then a subsequent reference of Tony that turned me away from what I thought was going to be a career at the bar into what I thought was going to be a short-term stint in academia. Now, my first act as an academic was actually to remember those 40-page bundles of notes that Tony had handed out for each class. And I'd been very impressed at the time and was still impressed when I became an academic, not only about their quality, but the fact they had never been published. And it seemed to me that they were frankly better than what else was on the market in terms of the other teaching materials that were available. So as a newly minted 25-year-old constitutional lawyer at the Australian National University, I approached Tony and asked whether he'd like me to help him turn these notes into a book, a textbook on Australian constitutional law. And I think it's only with the benefit of hindsight that I can realise just what a degree of trust Tony placed in me at that point in being willing to collaborate with me on that project, and just how generous he was as a mentor to hand over those notes, if you like, to enable me to try and fashion them into the book that became Australian Constitutional Law and Theory. Now, fortunately, his trust proved to be well placed, and the intellectual core that he provided of that book turned into what I think has been a really remarkable book, and certainly the publication of which I'm undoubtedly most proud in my academic career. That book, Australian Constitutional Law and Theory, has now sold coming up to 60,000 copies and is one of the most successful law books over the last 10 to 20 years. Consistent with Tony's approach to these type of materials, I'm glad to say the book is nearly 1,500 pages of small type. I understand that law students commonly call it the brick, no doubt with great affection, I'm sure. And in various editions, words have been literally squeezed into the page, and indeed in some editions the pages have been so thin in order to actually enable the book to fit within its covers that that's caused great problems for highlighters and the like. So I'd have to say that this book, across 5 editions, about to be its 6th edition, though sadly for the first time without Tony, is a book that really is a legacy, I think, of that teaching. And it's a book that success owes very much to that formative experience I had with Tony's notes back in 1989. And that collaboration with Tony is without doubt, I think, the most important in my academic career, and certainly the one that's involved the most joy for me in working with Tony on that, in what has been incredibly hard work across a number of editions. I'd have to say, as part of that Tony has certainly expanded my intellectual horizons way beyond what I expected or probably even wanted on various occasions. In working on that book with Tony, at various times I have become an expert in the yearbooks of medieval England. It was never clear what they had to do with the book, but they're in there, and they certainly demonstrate the eclectic nature of the book. And a real distinguishing feature of the book is how it delves often very deeply indeed into legal history, legal philosophy and the like. I've also had with Tony certainly long exchanges over the proper use of the ellipsis. And I went back once recently and discovered that on one occasion Tony had written me a 5-page email in response to a 1-line query of me about when we should use the ellipsis, when Tony had gone back and researched the full extent of the ellipsis, its origins, its use through medieval period onwards, in order to inform, if you like, how it should be used in our book. Now, I have to say that's consistent with a lot of the experience that Tony and I had. The depth and length that he brought to the book was my job often to savagely cut. But fortunately, between the two of us, we reached what was, I think, a good accommodation. Now, there's much more I could say about Tony's teaching, and certainly I would do so with great affection and many good memories. I could talk about the time that Tony actually fell asleep mid-thought in class, and I'm not sure anyone else, to my knowledge, has actually fallen asleep while teaching a class, but Tony did manage that. As students, we sat there for a short period, not quite sure what we should do, but eventually he woke up and continued to complete the sentence. It was quite remarkable, actually. But it only lasted, I think, 1 to 2 minutes, but I was very impressed, I'd have to say, that you could retain your train of thought across that period. Or the weekly sessions and the good humour involved in the Oxford Companion to the High Court of Australia, full of singing sessions and the like. I will say, though, that some things are certainly beyond Tony, and even though my knowledge of constitutional law owes fundamentally to Tony's teaching, Tony has never been able to teach me to sing, and that's something I have never and will never, I think, add to my repertoire. I'll now, it's probably past time, I suspect, that I turn to the body of my talk, but thank you for the opportunity for reminiscing, at least at the beginning, before turning to a topic that has engaged me for much of the last 12 years, and that is the anti-terror laws enacted in Australia. And I've chosen this topic because I got into this area because of Tony. I got into the area because, having written my undergraduate thesis on the Communist Party case, I wrote that as what I thought was an exercise in legal history. If you like, the laws that Australia enacted to respond to an internal threat of subversion, laws that were quite extreme in their impact, and it was thought to be a set of laws that we were never likely to see again in Australia. So when I wrote my thesis on late 1940s and early 1950s Australia, I expected that would be it for the subject, but lo and behold, of course, we re-entered a similar phase of lawmaking after September 11, and much of the legal history suddenly became very relevant, and indeed my thinking about the anti-terror laws since that time has been very much influenced by the discussions I had with Tony about that thesis and about how my own views as a legal scholar emerged at that time. Now, in talking about this subject, I do want to acknowledge it's a subject that I've worked on with a large number of people, and indeed some of those people are here. There's been academic teams of people who have worked on these laws, people I've worked with, such as Fergal Davis, who is here, Nicola McGarity, who is soon to join Macquarie Law School. I think you're very fortunate to be getting a very fine academic in Nicola next year, and others also who I've co-authored work with and who played a very large role in influencing my thinking. So I think it's important to reflect that this is an area that is the product of many, many minds. What I did, though, after September 11 was seeing what happened in that devastating attack. I was very quickly struck, not by the laws that were enacted, but by the, if you like, the conjunction of the rhetoric that we were seeing after September 11 and how that related so strongly to the themes that emerged as Australia battled against communism after World War II. For example, you might recall after September 11 that President George W. Bush famously said, "You're either with us or against us." Now, that was exactly the sort of language that was used in late 1940s Australia to say you're either with us or you're a communist. There's only one choice here, effectively. You're on our side or you're a traitor. To give you an example of that, this is an editorial from the Sydney Morning Herald on 7 November 1947 in setting out the threat that Australia faced from communism, not terrorism, but communism. The Herald wrote, "Communism is cold, harsh and ruthless, and it is building slowly and inexorably to the day when our democratic government will be superseded by a godless, tyrannical, communistic dictatorship. Any Australian born in this country who embraces communism is a traitor. There is no halfway. There has to be a choice between good and evil, and people must be either loyal or disloyal." Now, I think it's fair to say that Sydney Morning Herald editorials may have lost a little punch since that time, perhaps, but when I looked at the newspapers of the time, that was the rhetoric that was very consistently across the papers. And in fact, when people talk about the rhetoric in the war on terror, it actually was not as strong as what we saw at that time in Australia. The menace thought to be faced from communism was projected to a much larger level, and in fact around this time Sir Robert Menzies made many statements suggesting that World War III was imminent and that Australia was about to be engulfed by a new world war that would threaten our very existence. Now, of course, at that time the Parliament passed laws which sought to ban communism, and the High Court in 1951 in the Communist Party case, in a remarkable decision by world standards, stood up to the hysteria of the time and actually striking down that legislation. It's remarkable because the court did so against what appeared to be 80% popular support for laws banning the Communist Party, and it's a decision that is renowned in Australia and elsewhere as a vindication of the role of superior courts in protecting the rule of law, that they have a role in vindicating the rule of law even against what might be seen as overwhelming majoritarian pressures. It was that decision in particular that I focused on in my honours thesis written for Tony, and it was that decision that kept reminding me of the values at stake as we embarked upon a new round of lawmaking after September 11. I was particularly struck then and now by a statement by Sir Owen Dixon in that case that reminds us of what's at stake when we have laws that potentially overreach in dealing with a national security threat. Back in 1951, Sir Owen Dixon wrote, "History, and not only ancient history, shows that in countries where democratic institutions have been unconstitutionally superseded, it has been done not seldom by those holding the executive power. Forms of government may need protection from dangers likely to arise from within the institutions to be protected." And I think that statement, more than anything else, has really informed my philosophy of how I've approached Australia's anti-terror laws, and that is, in seeking to defeat the threat posed to the community by terrorism, we ought not to take steps that undermine the very democratic freedoms we are seeking to protect from terrorism. And that's, if you like, a basic mantra that sometimes is easily lost in the fear and grief after a terrorist attack, but it was something that the High Court reminded us of in 1951, and it's something that I think resonates down the law books to today. Now, even though I'm someone, by virtue of my study of the Communist Party case, who came to the anti-terror laws with a critical eye, if you like, a healthy scepticism, I'm nonetheless not someone who believes we ought not to have enacted anti-terror laws. I actually think there is a strong case as to why Australia, after September 11, ought to have enacted appropriate anti-terror laws. If you look at our national history in this regard, we actually had no anti-terror laws on the books whatsoever prior to September 11. The absence of anti-terror laws nationally in Australia prior to that time perhaps isn't surprising. We didn't have the sort of terrorist attacks that the United Kingdom had to deal with at various points, nor those of many other countries in our region. But we were dealing with a situation where, not having any laws on our books, we were faced with making anti-terror laws at arguably the very worst time. If you are going to have laws of this kind, it's best to make them before an attack, in preparation for an attack, not only to protect the community, but also because the laws are not shaped by the heat and controversy of the time. In fact, there's probably no worse time to be making anti-terror laws than after an attack like September 11, when the cry of the community for action is loud and the response of politicians is simply to give whatever they can in order to be seen to be acting as strongly as they can. But, as I've said, the fact that we didn't have laws, to my mind, doesn't mean we shouldn't have had laws, and I do recognise that many people have said we didn't need any new laws after September 11, but the work that I've done over more than a decade has led me strongly to the conclusion that we did need the right set of laws. For example, we had no laws in our books at the time dealing adequately with the problem of financing terrorist organisations. And if you want to deal with terrorism, one of the lessons that's been learnt is that financing is one area that does need to be attacked. That was just a major gap in our laws. More broadly, I'm of the view that our criminal law, as it existed in 2001, was not adequate to deal with the threat posed by terrorism. That's because the criminal law is very much focused on prosecution after the event. And I think the potential for catastrophic damage and loss of life when it comes to terrorism justifies an earlier point of intervention. That more needs to be done to prevent terrorist attacks than simply recognising that people should be prosecuted after the harm has been done. I'd also say that when it comes to the powers of our agencies, that even though we ought justifiably to be sceptical and cautious about the powers that bodies like ASIO, the Federal Police and others are given, nonetheless, those agencies do need appropriate powers to protect the community from terrorism. Those agencies need to be subject to oversight, safeguards and the like, but they do need powers of surveillance, they do need powers of questioning, and when those existing powers were looked at carefully, there were significant and I think important gaps that need to be remedied. I think also the case for anti-terror law has, I think, an international and moral dimension. If you look at the immediate resolution of the United States Security Council after September 11, that Security Council resolution required Australia to take the necessary steps to prevent the commission of terrorist acts and to establish terrorist acts as serious criminal offences. And if we wanted to be a good international citizen, to play out our obligations, it required us to legislate. And I think in legislating, we did so as a community to make it clear that these forms of political violence in places like New York, Washington, but afterwards Bali, Madrid, London, Mumbai, Jakarta and elsewhere, that these forms of political violence are unacceptable and are justifiably criminalised and prescribed by Australian law. So my starting point actually in analysing these laws is to say that we did need anti-terror laws, that credit ought to be given for recognising the gaps in our laws, and the question is ultimately, did we get the right laws? Did we get the laws that actually were needed, that are proportionate to the threat and contain appropriate safeguards? And here, unfortunately, is where too many of the laws actually run awry. When we look at the laws actually enacted in Australia, there's many striking features of these laws that mean that they're studied not just in Australia, but in many other countries as well. One of the most remarkable features of our anti-terror laws is just how many actually got enacted after September 11. Now, it's been 12 years since September 11, and you can divide that into two periods: the 6 years of the Rudd-Gillard-Rudd government and the prior Howard government to that. If you look at the Labor period, 13 anti-terror laws were enacted over that 6-year period, roughly a couple every year. If you look at the prior Howard era, during the hot period of this conflict, if you like, 48 anti-terror laws were enacted. In fact, a new anti-terror statute on average went through the federal parliament every 6.7 weeks during that 6-year period. All up, 61 separate anti-terror statutes have been enacted over the last 12 years. And these are statutes that fundamentally reshape basic norms of the legal system, introduce warlike powers not seen since World War II, or indeed in some circumstances never before seen in Australia. And because they were enacted so quickly, at an average of one every 7 weeks roughly over a 6-year period, things were put onto the statute book that never received significant or indeed adequate consultation or consideration. Now, Australia is remarkable in these numbers. One leading world academic on studying anti-terror laws, the Canadian Kent Roach, has a chapter in his book on anti-terror laws called Australia and Hyper Legislation, because he sees us as so unusual as compared to other countries. And this is what he says: Australia has exceeded the United Kingdom, the United States and Canada in the sheer number of new anti-terror laws that are enacted after September 11. This degree of legislative activism is striking compared even to the United Kingdom's active agenda, and is much greater than the pace of legislation in the United States or Canada. Australia's hyper-legislation strained the ability of the parliamentary opposition and civil society simply to keep up, let alone to provide effective opposition to their relentless legislative output. And it certainly seemed relentless at the time, as someone putting submissions into these inquiries, just how quickly one law moved to the next, and just like a domino, one to the next, what were thought to be fundamental assumptions of our legal system fell over as the laws dealt with them one by one. If you look at the laws, of course, the volume is, if you like, a what could be seen as not a particularly significant measure of their reach. I mean, it suggests activity but doesn't say much about the laws. But in terms of the reach and operation of the laws, they're even more significant than the volume of laws might suggest. Everything hinges on what actually is a terrorist act in Australia, and that's something that involves conduct engaged in or threats made for the purpose of advancing a political, religious or ideological cause. It's got to be designed to coerce a government or influence a government by intimidation or intimidate a section of the public, and then it goes on about endangering life or damaging electronic systems or the like. The fundamental insight here is that the definition, even though it's well crafted compared to many others around the world, makes no distinction between terrorists and freedom fighters. There's no doubt, for example, that under our definition, Nelson Mandela is a terrorist. There's also no doubt that the people who resisted Indonesia and East Timor are terrorists. The people seeking to bring down the Syrian government are terrorists. They're engaging in forms of violence for a political purpose designed to intimidate or coerce a government. And the definition simply makes no distinction between what we might see as morally justified acts of intimidation or violence against apartheid, for example, and those which can't so be justified. And that has very important implications. It means that there's a necessary and high degree of selectivity involved in who to prosecute, which organisations to ban, and it says a lot that when you look at the figures and statistics that the laws have been predominantly, almost completely in key respects, directed only at Muslim Islamic organisations and have not been directed at other, what might be seen as terrorist organisations. And that selectivity has been a major cause of concern in some quarters. The laws based upon that definition create a wide range of offences, not just committing a terrorist act, but mainly things to do with preparing for a terrorist act. My own favourite offence is if you simply possess a thing connected with a terrorist act and thing is not defined, then that's something that can give rise to many, many years in jail. The penalties are very severe. If, for example, you give money to an organisation and you're reckless as to whether that organisation might use the money for terrorism, let's say, for example, you give money to a Middle Eastern charity without really investigating whether that charity might give the money to Hezbollah, then you are subject to life imprisonment merely for being reckless in those circumstances without the need actually to have any direct intent of that kind. These offences can also be combined with other, what I call Inchoate offences, so can be combined with attempt and conspiracy and the like. And indeed, what's now increasingly common is we're seeing prosecuted people not even preparing for a terrorist attack, but a conspiracy to do an act in preparation for a terrorist attack. And it's going very far back in the chain of causation, where there's mere conspiracies, there's no need to have a plan, no need to have made a decision to engage in the terrorist attack, and it shows just how far back these laws go. And people subject or convicted under these laws are commonly jailed for over 20 years. We also see remodelled sedition offences at the time they were enacted in 2005. We put on the books there offences which meant that people could be jailed for up to 7 years merely for their speech and not their actions. At the time, it was well known in Parliament that the provision was flawed. In fact, the attorney at the time, Mr Ruddock, acknowledged they were flawed by saying that as soon as they were passed, he would actually send them in an inquiry to the Australian Law Reform Commission. It's one of the very few instances I can think of where Parliament has passed a law knowing it was broken, containing a lengthy jail sentence and indicating it sent it to inquiry after the event to work out how it could be fixed, rather than actually fixing it before it was enacted. We've also got warrantless searches now in the book so that police officers can enter people's homes looking for example, a thing connected to a terrorist attack without speaking to a judge or any other independent person. Terrorist suspects can be detained for twice the length of period as other suspects and even held for up to 7 days in some circumstances. Terrorist organisations can be banned on the say-so of the Attorney-General without any need for judicial involvement. People can be subject to a preventative detention order where they're not subject to charge or trial. They can be detained for up to 2 weeks. People can be subject to a control order for up to a year where they can be banned from talking to certain people, using certain technologies, subject to house arrest, and a person can be subject to a control order without any finding of guilt on what can be a rolling 1-year basis, and it's an order that completely ignores the concept of guilt or innocence. It simply enables people's liberty to be controlled on the basis of an order based upon what it's thought perhaps they might do in the future. The most extraordinary of the powers are those given to ASIO, which enable ASIO to bring in Australian citizens not suspected of any crime for questioning and potential detention for up to a week. People can disappear, literally disappear for a period of a week, in order to be forced to answer questions about family members, or a journalist about a source, or an academic about a line of research. And if a person refuses to answer a question, say about a family member, the person can be jailed for 5 years, even in some cases children. After the event, if the media wants to report the detention of someone, including perhaps a report that they were detained in inhumane circumstances or mistreated, the journalist can be jailed for 5 years for actually reporting that that has occurred. And not only that, if the journalist reports any operational information at all, they can be jailed for 5 years in these circumstances. And operational information includes a journalist reporting any information that ASIO has or had, without actually saying the nature of the information more broadly. And of course it means the journalist has to know all the information ASIO has or has had in the past. And if that information is reported, they can be jailed for 5 years. We've got new powers of electronic surveillance that mean that not only terrorist suspects, but anyone who it is believed the terrorist suspects might communicate with can be subject to surveillance. Lawyers who are engaged by terrorist suspects can be subject to surveillance. There's no right to legal professional privilege. Priests and other people who might have that type of engagement can be subject to surveillance. We've also got a special power of the Attorney General to close down a courtroom in circumstances that an accused may not see all of the evidence led against them in its original form. And if it's thought that that might give an accused an unfair trial, the legislation says specifically that an unfair trial is to be neglected because the greatest weight is to be given to the interests of national security in such circumstances. We've also got a broad range of new offences dealing with the classification and the censorship of material that are extremely broad. One, for example, says that any publication or film or computer game that advocates terrorism itself can be banned, but advocates is very broadly defined. So if you, for example, wrote a book praising Nelson Mandela and his struggle, then that's something that clearly could be banned in Australia. His autobiography is a book that could be banned in Australia without doubt. But the definition is broadened, so advocates includes anyone who directly praises the doing of a terrorist act in circumstances where the praise might lead a person of any age or with a mental impairment to actually want to engage in a terrorist act. Now, normally the law always works on the basis of a reasonable person, like test. This is a very rare instance where the law operates on the basis that a book can be banned because of how it might lead a person with a mental impairment to act. And the law actually defines mental impairment to include a person suffering a severe psychosis or other very serious mental illness. So heaven knows how the classification board is meant to do its job of determining how a publication might lead a person to act based upon the mental illness that they are suffering. Now, when you look at that body of law, and I could certainly go on, my thesis is that we have ended up with laws that go greatly beyond the sort of laws we actually needed and ought to have received in Australia. What we've seen is laws that responded to the events of the time, the rhetoric of the war on terror. And it's not surprising at a time when Australians were dying in Bali, in New York, Jakarta and other places, that these laws were made in circumstances where often fear, grief and political opportunity rose very high in the debate. And of course this is a dynamic that is very well known. Alexander Hamilton, for example, writing in the 18th century, wrote about the tendency of politicians to take advantage of the fact that at times of crisis, communities will, to be more safe, will be willing to run the risk of being less free, that they will trade off freedom in order for safety, even if perhaps the illusion of safety is sometimes all that's involved, or even if in doing so they actually end up sacrificing the democratic freedoms that ought to be protected. My own view is that one of the reasons we got such an extreme body of law, why our legacy is so significant compared to other countries, is because Australia now is the only democratic nation in the world that doesn't have any national Bill of Rights. We made these laws without any yardstick against which to measure whether the laws appropriately dealt with things such as freedom of speech. Hence we end with a clause which actually provides for the censorship of material based upon how a mentally ill person might react, or sedition laws that have no parallel in other like nations. Now, I wouldn't suggest that a Bill of Rights is a stop to these laws, and in fact the experience of the United States and other places very clearly is that the exigencies of the time will overwhelm even strong forms of legal protection in a Bill of Rights. But certainly in those countries, a Bill of Rights ameliorates what was done, reminds people of those values, informs civil and political debate in fundamental ways that shape what's actually occurring. And perhaps even more significantly at the moment, a Bill of Rights provides a point to reassess those laws years after they are enacted. And what we're seeing now in America, the United Kingdom and elsewhere is instances where the values in a Bill of Rights, perhaps ignored or not given enough weight at the time their laws were made, are being re-engaged with in order to recognise a need to recalibrate the anti-terror laws that were passed. In the United Kingdom, for example, in 2011, the new coalition government there launched an inquiry into their anti-terror laws. Home Secretary Theresa May talked about the need to reverse the substantial erosion of civil liberties brought about by their anti-terror laws. She talked about wanting an anti-terror regime that is proportionate, focused and transparent. And they went through a process that actually led there to the abolition of their control order regime, the replacement with a different regime. And what we've ended up now is that the UK has repealed its control order regime. The regime of control orders we copied from them, we have never removed from the statute book. So we're left with copying something that's now been discredited in the jurisdiction we copied it from. You have taken no steps whatsoever here to actually even follow the path of the United Kingdom on this. We've ended up with a much more severe response to the London 2005 bombings than the UK has, which says a lot how sometimes these issues can be magnified in Australia. As to what we perhaps can do now that we have the laws on the books, given the weaknesses in our system, well, one is, of course, is to recognise those weaknesses, and I think to recognise that it's not enough to simply rely upon political goodwill at times of crisis to get the right laws. You do need the appropriate legal frameworks. But what we've got is a body of laws on the books that are having a profound impact, not just in the area of anti-terror law and policy, but more broadly elsewhere. Because even though many of these laws aren't even being used to any great extent, the ASIO detention power has never been used, they're increasingly becoming seen as normal. People are accepting them as part of the legal landscape. They're accepting that they provide a precedent for laws elsewhere. And where we're really starting to see the seepage of these laws is into the law and order debate at the state level. The anti-biking laws that are sweeping the country involve a control order regime copied from the anti-terror laws. Former South Australian Premier Mike Rann said, "We're allowing similar legislation in this state to that applying to terrorists because bikie groups are terrorists within our community." We're also seeing at the state level their toolbox expanding through increasing tough on crime measures that are not only involving control orders but a range of other measures taken from anti-terror law in bail and other circumstance, where people are taking the view that, well, if it's done in the anti-terror level, in circumstances where the books now appear to be permanent, why wouldn't you copy them in looking for the tough law and order policy? Hence consorting and other laws we're seeing again at the state level. We've got no shortage of reports, though, that are recognising that we do need to make changes to these laws, that in fact this normalisation needs to be reversed before we end up with a body of law that really replicates what we're seeing at the federal level, at the state level, in other contexts. We've had a myriad of inquiries that recognise the need for change, and two this year are very significant in being independent inquiries that mirror many of the concerns that I've talked about tonight. The first report from the Council of Australian Governments was a committee headed by Anthony Wheely, QC, a retired New South Wales Supreme Court judge who has presided over anti-terror trials. His committee included senior police office members, and the second report was by a leading member of the New South Wales Brett Walker SC, who was Australia's first independent monitor of anti-terror laws. Both of those reports were released earlier in this year, and both are very significant in amounting to careful, forensic, independent analyses of these laws from people in many circumstances that you would expect to be sympathetic to the laws as enacted, such as the police. The reports themselves recognise the danger posed to the community by terrorism. That's their starting point. We do need appropriate laws on the books. But what they do find is that in far too many respects, the laws themselves are unnecessary, go too far and lack appropriate safeguards, and they recommend urgent change. They recommend, for example, in the case of Brett Walker, that ASIO's power of detention that enables non-suspect citizens to be held for a week simply be to be repealed as dangerous to our democracy, that preventative detention orders should not be on the statute book, that some of the offences are far too severe that people can be jailed for lengthy periods without the requisite criminal intent, that major changes need to be made to control orders, or in Walker's case, control orders simply repealed. There's a host of recommendations that strip away any pretence that Australia has the right anti-terror laws on the books. As they both make clear in these reports, we've got a body of law that is actually dangerous and corrosive to the quality of our democracy, and that unless we are vigilant and careful with these laws, we will continue to have a body of laws that in the future could be misused by a scrupulous government and indeed could pose great dangers. As to whether the reports will be implemented, well, certainly the jury is out on that, but the early signs are not positive. Australia is a country that leaps into enacting anti-terror laws, but at our leisure considers fixing them. The two reports were released in May of this year, but the timing of their release gives you a sense as to how much the government wanted to engage in a debate about fixing the anti-terror laws. They were released at arguably the best possible time in the yearly cycle to hide an issue, that is 5 p.m. on budget day, when all of the journalists are locked up, when all of the attention is turning to the budget which is about to be delivered, when the deadlines for the newspapers have closed for the day on other forms of news. So they were released at the point that was guaranteed to minimise any form of scrutiny or analysis, and indeed the newspapers gave them little or no attention whatsoever. It was a very effective strategy. Now, at the time, the government said they were releasing it and that they would take some time to think about implementation, and you would have thought perhaps in the election itself that's the time you'd expect to get a response about whether these reports would be implemented. And the Law Council of Australia put questions directly to the major parties asking whether they would implement these reports. Labor said, and I quote, "A re-elected federal Labor government will carefully consider the reports before reaching a final position on the substance of the recommendations." In other words, we're not giving any commitments of any kind. And even after having these reports in the case of Brett Walker since last year, they weren't prepared to form a view on making any changes whatsoever to the laws. The coalition response was that they would carefully consider the recommendations in Walker's report, but have no plans to make material alterations to the anti-terrorism legislation introduced since September 11. It means that even though these reports, commissioned in both cases by governments, in circumstances where the people of the highest integrity, where they come from agencies themselves sympathetic to the anti-terror laws, where they have identified major weaknesses in the laws relating to their unfairness and disproportionality, that we still have yet to have any commitment to implement any aspect of those reports. That's something that is deeply concerning. Just to wrap it up, what I've tried to do is to give you a sense of the work that I've done since working with Tony many years ago in this area of the war on terror. Over the last 12 years, it's been a major focus of my academic life over that period, and it's helped me form views, if you like, especially about Australia's responses more generally to national security. What we've seen, I think, is a need for anti-terror law become twisted and distorted by the rhetoric of the war on terror. We've got laws on the books now that are here for a greater duration than World Wars I and World War II combined, because they're in response to a conflict without any conceivable end. What we've got are sanctions on the statute book relating to imprisonment and the like that completely ignore basic concepts like the right to a fair trial or guilt and innocence. And we have sanctions and powers that frankly weren't even found in some cases during the darkest and hottest days of World War II. Not only that, these are things that it seems there is no political will to remove, and we're facing significant dangers where they're becoming normalised and accepted at the state level. I think it demands ongoing vigilance, ongoing study, but also strong political commitments to actually dealing with this, because we're talking here about fundamental aspects of the Australian legal system that over the longer term will pose great dangers, I think, to our democracy. I think also these new anti-terror laws more generally expose deeper problems with Australia's legal system. These laws, perhaps more than any others of recent times, show just how dependent our legal system is not upon strong legal protections for human rights, but on a series of assumptions about the rule of law, fairness, equality and the like. Those assumptions or conventions are things that we depend upon our political leaders to respect and to enforce, and of course in the main they do. But in circumstances like anti-terror laws or where emergencies and interventions arise, what's become clear is that unfortunately our leaders of all political persuasions are all too willing to depart from those fundamental conventions and assumptions. And what we have, unfortunately, is a series of bedrock principles in Australia of our democracy that are exposed as all too fragile. The result, I think, of that fragility is, as I put in the title of this talk, what I see as the legal legacy of Australia's war on terror. Thank you.
Well, thank you so much, Professor Williams, and on such a thought-provoking lecture on a topical issue. I think the lecture has just done justice to Tony Blackshield in condensing 12 years of research in 30 minutes' time. Thank you so much. The person who we are talking about, Professor Tony Blackshield, and doesn't need any introduction. As you have heard, he's a great teacher, great researcher, great scholar, and we have a proud history and fond memories with Tony Blackshield. Just to give you some dot points about Tony Blackshield before I invite him, Tony Blackshield began his teaching in the Department of Jurisprudence and International Law, the University of Sydney, in 1961, before becoming one of the original 7 faculty members who founded the Faculty of Law at the University of New South Wales. He worked for 10 years as Professor of Legal Studies in the Department of Legal Studies at La Trobe University, and then we had 11 years of Tony, when he started at Macquarie in 1988 till 1999. Tony was Professor of Law and Dean of Law at Macquarie University. As you know, that Tony is regarded as a leading scholar, an expert in constitutional law, and who has had groundbreaking and original contributions to public law and jurisprudence. Tony Blackshield has published extensively on jurisprudence and constitutional law, particularly the constitutional law of Australia and India. Ladies and gentlemen, could you please welcome Professor Tony Blackshield.
Well, towards the end, when George started talking about the political response or non-response to the reports on what we should be doing with the war on terror, the law of the war on terror, it became fairly depressing for a while. But on the whole, this is a very happy occasion for me, for many reasons. When I go up to the law school and see that there's a Tony Blackshield room, I feel very happy. My wife is not so happy about being married to a room, but there you go. When I see that Shawkat in his early years here got the Tony Blackshield Award for the most prolific researcher, I feel happy. And the idea that there's an annual Tony Blackshield lecture, I think is just great. And my friends keep saying, and you're not even dead yet. But it's especially happy tonight to have George give this lecture, because I've enjoyed working with George ever since that time 22 years ago when I was supervising his dissertation on the Communist Party case. A friend of mine of my own vintage, Zeke, and I started law school together in 1954. At 54. My friend later spent most of his career working in New York, but on one occasion he was sitting on a plane next to Sir Frank Kitto, and Kitto launched into a great paean of praise about what a wonderful institution the High Court of Australia is, and how it's the only institution in this country that can be relied on for the protection of human rights. And my friend gasped incredulously and said, "What has the High Court ever done to protect human rights?" And Kitto said, "The Communist Party case." It's not quite true that that was the only thing in the High Court's record. And it's certainly true that there have been more good things since, especially when George was there as an associate. But it is true that our constitution has been too much about powers and not enough about rights. And you do see that working through the whole of our legal system. And I think what has always driven me is the feeling that law should be about rights and freedoms. Many years ago, when Eric Willis was Chief Secretary of New South Wales, I think at the time he might still have been called Colonial Secretary, I heard him give a speech at a symposium in which he said that law is by its nature necessarily a repressive force. And it's true that it can be that, but I would like to think that law can also be a liberating force. And that's certainly what's always driven me in my work on the law. And you can see that George has followed that same line in everything that he's done. So it's always a pleasure to work with George, to listen to him. Back when I was young, I used to do a lot of media commentator. I'd been educated by Julius Stone, who instilled in us the idea that academics have a duty to speak out on public issues. Back in those days, he said that because we were blessed with academic tenure, that gave us a freedom that other people don't have, and it was our duty to take advantage of that freedom. Nowadays, of course, we don't have academic tenure, but like many other aspects of the universities, that's gone down the gurgle hole. But I think we do still have that duty, and it's very good to see George doing that so often, and always saying pretty much what I would have said myself. Although I must say that in his recent article on Prince Leonard of Hutt, I was sorry that he didn't include a paragraph about King Ron of Wallandilly. Nevertheless, it's always been a pleasure to listen to George and to work with him. The origin of the Blackshield and Williams book, I don't remember exactly as George remembered it. As I understood it, the deal was that George, by turning my notes into a book, George would get a book to his name for something that was really my work, and I would get a book to my name without lifting a finger beyond what I'd already done, and we both thought that was a good deal. But as it turned out, we both had to do a lot more work and have continued to do so over the years. There was a principle that if we disagreed on something, if we had opposite views on a question, what we would do in the book was to put in both views and not take a stand either way. But I don't think it was ever necessary to invoke that principle, because I think we always did agree. In the years when George and I worked on the book together, it really was a joint effort. Every chapter was worked over and reworked over by both of us until both of us were happy with it, and it was a very enjoyable experience. As George has said, that's not my experience anymore. I'm now well and truly retired, except that George has dragooned me back into writing a chapter for another book. And I got an email yesterday telling me that the deadline is the 25th of October, and that's not good news. But it's a chapter that is essentially about the politics of 1930. So as George did when he was writing about the Communist Party case and read a lot of papers from 1950, I've been reading a lot of Australian newspapers from 1930. And one thing that keeps coming through is indignation and horror about an awful terrorist in India who's disrupting civilization as we know it, a really dangerous figure called Mahatma Gandhi. So terrorism has many guises, and it's a name that keeps coming back. I shouldn't go into the rest of my 1930 project because it's irrelevant, but it does show how history tends to repeat itself, so I will. I'm writing about the period when Jim Scullin was Prime Minister. He was only Prime Minister for 2 years. It's the story of a Labor Prime Minister who came to office in such an enormous electoral landslide that the outgoing Conservative Prime Minister even lost his own seat. But almost immediately, this new Labor government was faced with a global financial crisis. They didn't have control of the Senate. People have criticised the Prime Minister for loss of nerve because at a crucial moment they now think he should have had a double dissolution and he didn't. Things got worse and worse. He liked grandstanding on the world stage, but while he was away things got worse and worse at home. And in the end his Prime Ministership was terminated early by a rebellion of his own supporters. And this is 1930. So history does repeat itself. Anyhow, back to the book, and it's not my book anymore because in a couple of months there'll be a new edition that George and Sean Brennan and Andrew Lynch have been working on, and I've played no part in it, and I'll be interested to see what they've put in and even more interested to see what they've cut out, but it's really none of my business. And when the last edition was launched at the beginning of 2010, I made it clear that that was the end of it from me, and I told them I was giving my swan song, and just to make clear that I meant it, I'd better do it again. I'll be doing no more constitutional law and theory. The reports of the courts had me all out of sorts and dreary. When the High Court couldn't agree and divided 4 against 3, the moment I saw it I knew there'd be 7 different points of view. Ask me how do I feel now the 5th edition is over. Well, all I can say is I feel like I'm dancing in clover. I was weary and bleary, but now from theory I'm free. So I'm cheery now, 'cause it's cheerio from me.
Thank you very much. And this is probably one of the reasons that we come back and to listen to these songs. And we hope that it will continue, and we'll have many more occasions to hear from you, Tony. And of course, you are most welcome to revisit that room in the law school. And we have many memories we have kept in that particular room. So I would like to thank everyone for coming today, and it's a moment of joy and pride for us as a law school community. And can I ask you all to acknowledge the contribution of our executive assistant, Eleanor McGee, in putting together this event. So Eleanor, thank you very much for your help. Also, I just wanted to mention that I would like to send regards from the Dean of Law, Professor Natalie Klein, who is on leave at the moment, and she will continue her leave up until July next year. So I'm acting until July next year, and she asked me to send her regards to you all. Law school is going from strength to strength, and it's an occasion where we can tell you how well we are doing now, and we have new programs, students are doing great, and we have a renewed focus of engaging with the broader community. So we are trying to establish the platform where our alumni and current Macquarie Law staff and students are all connected. We have a Macquarie umbrella, Macquarie Law School family, and you are part of that family. So thank you very much for your support for this event and for all other events that we organize. We have a new program we are launching next year, 2014. We have Juris Doctor being introduced, the law school, and also we have 4-year LLB. So we are very excited with all those new programs and new opportunities and the presence of law school not only in Macquarie but in the broader community. Thank you very much. And I'd like to close these proceedings now. Thank you.